Good afternoon, good morning, ladies and gentlemen. Welcome to the SIAC Northeast Asia webinar on arbitrating gas price review disputes in Asia. Thank you all for joining us today from around the world. My name is Michelle Sonin. I am the head of Northeast Asia at SIAC, and I will be your MC today. Before we begin, I would like to quickly draw your attention to the Q&A button at the bottom of your screens. Please use that to submit questions to the panel, and our speakers will try to answer as many as possible at the end of the session. I also note that this webinar is being recorded and it will be posted on SIAC's YouTube page and other social media. I am especially excited for today's webinar because it is one of the first in Asia dedicated to gas price review arbitrations and a first for SIAC on this topic. We have an esteemed panel of experts who will be sharing their expertise and perhaps a few war stories. Our panelists today are Mr. Peter Chow, partner at King & Spalding in Singapore, Dr. Boaz Moselle, Executive Vice President at Compass Lexicon, joining in from London, Dr. Wolfgang Peter, partner at Peter & Kim in Geneva, Dr. Matthew Seacombe, partner at White & Case in Singapore, and Ms. Angela Yuen, Deputy General Counsel at JIRA in Tokyo. Moderating the discussion will be Mr. John P. Bong, member of the SIAC Court of Arbitration and partner at Peter & Kim in Seoul. I will now hand the floor over to John to get the discussion started. John, please.
Thank you very much, Michelle, for the kind introductions. A very good afternoon, evening, or morning to everyone, depending on where you're tuning in from. We've come together today with some of the world's leading lawyers and experts to discuss some issues surrounding Asian LNG price review disputes. I am grateful to the SIAC for holding this special event today. As many of you are aware, Asian countries are the biggest importers of LNG in the world. And while price review clauses have been a feature of long-term LNG sale and purchase agreements for some time, Asia has not seen the same glut of price review disputes and associated LNG price arbitrations that Europe has experienced. However, that dynamic is now changing, and we have been observing a spike in price review disputes that go to arbitration in recent years. I am honored to have the opportunity to moderate this exceptional panel today, and while I don't have the fortune to have them next to me, I am glad that many more of you can listen in today. Our aim with this webinar is to help transfer some of the expertise of our panelists to the audience. While I recognize that 75 minutes is not sufficient time to discuss all the legal and practice-related issues that surround LNG price review disputes, my hope is that everyone attending this webinar will find that they are enriched with specialist knowledge that they may not have previously had. When all the panelists are completed, depending on the amount of time left, we will take some questions from the audience. Now, to open the proceedings today, we are very delighted to have Angela give us some insight about JERA, the commercial rationale of price reviews in long-term LNG SPAs, and general observations from the Japanese buyer's perspective on the Asia-Pacific LNG market. Angela?
Thank you very much, John, for the invitation to join this panel, and a good evening to our audience. Oh, sorry. Having some difficulties with beg your pardon. Oh, here we are. So to start, let's talk a little bit about JERA. JERA is a relatively young company, and we were created in April 2015 through the consolidation of the fuel and thermal power businesses of two of Japan's largest electric utilities, Chubu Electric and Tokyo Electric. Since that consolidation was completed in April 2019, our business now consists of the entire energy value chain, from upstream development, fuel procurement, transportation and trading, to power generation, electricity and wholesale gas. Next slide, please. JERA is responsible for approximately 30% of the electricity produced in Japan, And we also have a large international power generation portfolio. Japan is the world's largest importer of LNG. And as JERA procures over 40% of the LNG imported into Japan, this makes us one of the largest buyers of LNG in the world. So we're here this afternoon, evening, morning to discuss price review arbitrations. So firstly, let's have a look at why we have price reviews in LNG SPAs. As you can appreciate, the development of and exploration of gas resources require huge investments and usually external financing. Long-term offtake contracts underwrite these developments by providing continuous cash flows necessary to make the projects bankable because of the take-or-pay mechanism. These take-or-pay commitments present substantial risks for the buyer unless the buyer is able to resell that gas in its downstream market with one or more back-to-back contracts that can earn an adequate margin. To achieve this, two things are needed. Firstly, a competitive purchase price in the downstream market at the time of execution. And secondly, a contract mechanism that will ensure the price will continue to reflect the downstream market over the life of the long-term SPA. Because changes in the legal or regulatory framework or the behavior of downstream buyers can impact the market value of gas. From a buyer's perspective, price reviews are critical in maintaining competitiveness. Next, let's have a look at LNG price reviews in Asia Pacific. Price review clauses are a feature of long-term SPAs supplying LNG into Asia, but not a lot is known about the actual price reviews that have taken place with Asian buyers, because these negotiations are by their nature highly confidential. However, there are media reports of various forms of price reviews, primarily negotiations, but also other methods like mediation or expert determination. Reportedly, Japanese buyers are involved in a number of these price reviews, and there has only been one publicly reported price review arbitration in Asia Pacific. This was initiated by KOGAS against the Northwest Shelf joint venture that is operated by the Australian LNG giant Woodside Petroleum. So compared with our European counterparts, I think it's fair to say that price review clauses in Asian LNG SPAs have been left relatively untested in formal disputes. Why then is there a lack of formal price reviews in Asia Pacific? Academics and commentators on this topic will cite a number of contributing factors, but in the remaining minutes that I have, I'll just briefly touch upon a few of these. First of all, plain and simple, it may be that the SPA simply do not explicitly provide for arbitration to resolve pricing disputes. In other words, there is no direct contractual recourse. Secondly, many Asian parties have a strong preference to resolve disputes through negotiation rather than adversarial means. This is particularly the case with Japanese parties because harmony is a guiding philosophy that affects many parts of or features in the Japanese society, including business. Working in harmony is regarded as a crucial element of productivity. So you'll find that Japanese parties have a tendency to be indirect, mild, and extremely courteous, even in disagreement. There is also a strong perception amongst Asian parties that initiating arbitration will damage ongoing commercial relationships, which is highly undesirable if the parties have to continue to work together or have a broader business relationship. These concerns are particularly acute if the primary sellers and the buyers are of the same nationality. So for example, if JERA is a buyer and Mitsui or Mitsubishi Corporation is a seller. It is also not uncommon for a related party of the buyer to be one of the owners of the LNG project because offtake rights are often tied to equity investments into LNG projects. Another reason, and the last that I will talk about, is that the outcome of any arbitration of price review dispute in Asia Pacific is relatively harder to predict compared to Europe because of fundamental differences in the market and the price review mechanisms. From an in-house perspective, one thing is for sure. A negotiated commercial outcome between the parties is always preferred over formal disputes resolution process. Apart from preserving the harmony between the business partners, a negotiated commercial agreement allows the parties to retain control and remove the uncertainty in the equation. This is important when one considers that price review arbitrations are extremely high stakes. Changing just a few cents per unit of gas can shift hundreds of millions of dollars between the parties because of the very, very substantial volumes that are delivered during the life of a long-term LNG SPA. So with that, thank you for your attention.
Thank you, Angela. I'm certain our audience was enriched with your insights, especially since Japan is the largest, as you said, the importer of LNG in the world. I understand that you have some questions for the panelists today, some free advice, as it were. I will give you, of course, an opportunity to ask them when our panelists have done speaking. Now, our next speaker, Dr. Wolfgang Peter, is not only a cherished colleague of mine at Peter & Kim, but one of the world's most highly regarded arbitration practitioners with a specific expertise in price review disputes as counsel. He will be focusing on tricky issues that often confront parties when a dispute over price review arises. Will an arbitral tribunal have jurisdiction when price review and arbitration clauses exist concurrently? And if yes, what are the limits to its powers? Wolfgang?
Thank you, John. Yes, well, this point is there are two clauses. One is a jurisdiction clause, and the other is an arbitration clause. So the answer for me is clearly yes. When there is a specific price review clause and an arbitration clause, then they play between the two permits for the arbitral tribunal to exercise its jurisdiction, unless these two clauses are badly drafted, are contradictory. There have been arguments made that if the price review clause does not refer back to arbitration, in other words, does not invite for arbitration if the price review process is unsuccessful, then you cannot be certain that the arbitral tribunal will have jurisdiction. That becomes, of course, a problem of interpretation, and that may be varying depending on who the arbitrators are, what applicable law comes into play. But normally the answer for me is clearly yes. Now, I would like to make one side remark, because I heard Angela say that in Asia, there is a fear of deterioration of relationship if an arbitration is started. And I understand that. But one must understand that price review arbitrations are different from normal arbitrations. In usual arbitrations, one party invokes violations of contract, breach. It can become very acrimonious. So that is very different from price review arbitrations. In price reviews, first of all, the parties start to negotiate. And if that negotiation is not successful, then they put the continuation of the negotiation, if I may say so, in the hands of arbitrators and experts. But it remains very civilized. So of course, it's an arbitration, technically speaking, but not the type of arbitration where you invoke breach of contract. So I think that the fear that the harmony is not preserved is overrated. And of course, I believe that in Asia, given the economic stakes in these contracts, you just won't have another choice if the discussions don't come to a successful conclusion. Now, let me move on to the second point, which is on my list. What are the limits of an arbitral tribunal's mandate in terms of price adjustment? Well, first of all, an arbitration, an arbitral tribunal can redefine the price. It's quite clear, because by definition, the arbitral tribunal has to apply the provisions. And the provision itself, of course, may limit the powers of the arbitrators. This is the important aspect I want to talk about. These provisions can provide guidance and limitations, and they often do. Guidance, further, is very important when you check whether there is really a case for a price review. For instance, if a party says the price under the contract is too high, then the clauses quite often provide guidance of what the arbitrator should look to see if the price should be adjusted. It will say that you have to look to comparable contracts. It will tell you what points in time you look. It's a substantial difference between the beginning and the end of the time period. The arbitral tribunal will check that. The arbitral tribunal will have to figure out what the true value of gas in the market is. And once it has established this, compare this to the contract price. Now, these are complicated mechanisms. I've been involved in various arbitrations where you have to define the value of gas, and then one of the methods is to do netback calculations from the end user price. I won't go into the technical details. That's complex. But to sum it all up, the clauses provide for guidance. So there is no, if you want, unlimited freedom of the arbitrators, because they are held to respect this guidance, and they usually do. And then the clauses also provide for limitations for what the arbitrators can do, because they introduce economic criteria. For instance, they will say there may be a price adjustment, but it has to permit the buyer to sell economically. Of course, practically speaking, that's not easy to define. What does it mean to sell economically? For instance, a buyer will say, I must have a profit. That sounds very logical, but how much? How does an arbitral tribunal define what a reasonable profit is under the contract when it adjusts the price? These are all, if you want, discussions that take place, but they take place among the parties with the experts and the arbitrators. They are carefully reviewed. I've seen a couple of arbitrations where the clause says the buyer must be able to sell economically, but the seller also must be able to sell with a profit. Now, then you are sometimes, depending on the market conditions, you're in a very difficult squeeze position, because if you have both these criteria, it's very hard to work out a reasonable middle name where each side is going to be satisfied. Then you see more recent clauses in Europe where gas hubs and the liquidity on gas hubs can be criteria in order to adapt prices. Now, beyond the guidance and the limitation in the clause, another way what limits the powers of the arbitrators is for them to determine the trigger. I think you're all familiar with the fact that gas price review clauses, first of all, have a trigger. In other words, to see if there were changes in the economic circumstances in the relevant market that would trigger a gas price review. Now, the arbitral tribunal can only make, for instance, a decision by saying, as an example, yes, these conditions are met. And the arbitration would stop there. And the next step would be expert determination, which is more technical, and the experts are more qualified often than the arbitrators to review and to rewrite the price formula. That's one possibility. But I don't think that the majority of clauses provide for, if you want, dual arbitration and expert determination in a subsequent sequence. Another way, which is quite often used in order to limit or to be cautious for the powers of the arbitral tribunal, is that the arbitral tribunal renders an interim award, and then it will give to the parties a time frame. For instance, I see quite often 60 days in which to agree. And if the parties don't agree, the arbitration starts again. And what does that mean? That means that now the parties have clearly accepted the risk that the arbitrators themselves will adjust the price and not an expert determination. The downsides of that method is that the arbitration will take much longer if there is a two-step arbitration. And the downside also, which I see, is that the interim award, once it's rendered becoming res judicata, it might well be that in the subsequent phase of the arbitration, the arbitrators discover that they were too hasty in deciding certain aspects, and they're bound by them. They cannot get back on them. So nothing is perfect. And then I would say there are other aspects of limiting de facto, not de jure, not legally speaking, but practically speaking, the powers of the arbitrators. And these are various elements which come into play in most of the arbitral proceedings. One important point are what I call the flexibility elements. In other words, you can vary the volumes of gas which is yearly to be delivered. Discussions will be held, suggestions will be made. You can vary the take or pay clause, which is expressed in percentage of the annual contract quantity. You can say you bring it down from 85%, I see it now in one discussion, to 71%. You can also vary what you call the make-up clauses, which are clauses by which you catch up gas which has not been delivered under a take or pay clause, and you make it up in subsequent years. So these are, if you look at them, they are in fact limitation of the powers, because the arbitrators will discuss them, they will entertain a discussion, and the parties participate in these elements. And particularly for LNG, which is the key in Asia, flexibility is important in terms of diversion or destination clauses. I see that a lot, because you can say that cargoes can be diverted to another port where prices may be better, another hub, and contracts provide for diversion of cargoes often, but ask for sharing of profits, of the extra profits between the seller and the buyer. There are various mechanisms. I had one arbitration between US and Europe, and that was quite a discussion. And then you can also have discussions on access costs, third-party access costs, because LNG has to be unloaded, has to be regasified, storage, transport. There are various cost levels depending on what type of services a buyer is going to choose for these elements. Now, what is important with all of these elements I quoted now, they are not part of the price review clause. So the arbitrators do not have jurisdiction over those elements. That's the legal side of it. But in practice, what I see is that there are suggestions made, and frequently these elements, when they come into play, they, if you want, can vary or have an effect on the price variations. In other words, you don't rewrite the clause totally under one criteria, but you play on the other elements to come to a reasonable price. John, I think I have already overstepped my time, so I stop here.
Thank you, Wolfgang. And very quickly, one question for you, and that's because you are arbitrating these cases once in a while, as well as counsel. Considering the importance of expert reports in these cases and the appointment of tribunal-appointed experts, how does the tribunal ensure that the decision-making power is not effectively delegated to the expert? That is, how does the tribunal avoid a situation where, as Alexi Moore noted in 2006, quote, a tribunal-appointed expert may become the de facto decision-maker in the dispute? Very quickly, if you can, okay?
Okay, well, very quickly. The points I made before already limit the scope of change. And that scope is, of course, true for the experts as well. They cannot override contractual provisions. One of the things, that's a personal point of view. I think that you are well advised to have only party-appointed experts, because party-appointed experts can be under better control of the arbitral tribunal, because they're on both sides. The arbitral tribunal looks to them, tries to compare their positions. What I personally use is what I call witness conferencing. In this case, it would be expert conferencing. I do this quite extensively when I'm sitting as an arbitrator. And these means that the experts are sitting together at the table in front of the tribunal. They have to explain why they have different views. They have to explain their underlying assumptions, the elements they use, and you can narrow the positions between them. And to the extent you cannot completely narrow them, you understand where the differences come from. Then I mentioned the interim awards, the step-by-step approach, expert determination, but that is, of course, giving the expert very large headroom. And finally, I say ironically, the arbitrators should have to work hard. That's not what you always see, to be honest. Arbitrators must work hard, because if they can understand what is going on, if they can understand the materials, if they work themselves into the mechanisms of the price review clause and so forth, then you have a better control. They shouldn't say, oh, we leave that to the experts.
Thank you very much, Wolfgang. Now I'll be turning to two other leading counsels in these type of disputes, Matt Seacombe and Peter Chow. First, for Matt, I have two questions. Considering how technical these disputes are, how do you understand the counsel's role in these cases? And in your experience, what are some things counsel teams and experts should keep in mind to achieve the best results working together? Matt?
Okay, thanks, John. I think in price reviews, lawyers have to do something which lawyers don't normally do, which is be humble. And that's because for the most part, I find that these price reviews are not resolved by the kind of finer legal points, but they're fundamentally an economic exercise that is decided based upon the changes to the market and the data that's available and what that data actually tells you about the market. Now, that's not to say that lawyers don't play an important role. They do, and specifically, they play two key roles in price reviews. The first is that they play the role in putting forward arguments as to the price review clause's interpretation. And these clauses are often drafted in a deliberately vague way because they're designed to be in place when the SPA is signed, but to last for say 20, 25, 30 years, depending on the SPA's length. Now, because of this deliberate vagueness to take into account an uncertain future, there's quite a lot of opportunity for lawyers to kind of argue as to exactly what the clause means, which can have a big impact on the price review's outcome. And often those arguments, have to be based on first principles, understanding the nature of the commodity, and understanding the nature of the market. The second thing that lawyers have to do in price reviews is that they need to be able to kind of package the material to make the chaos and the complexity of price reviews understandable. Because as Wolfgang said, well, it's very hard to really understand these things. And one of the roles of the lawyers is to write memorials in such a way that it brings together, the expert material, the data, often technical experts and other things, and packaging in a way that's both comprehensible and clear, but also persuasive in favor of your client. Now, the second part of the question John asked was about how teams work together really well. And I think that there are two elements to what I would consider a really successful price review team. The first thing is, I think it really has to be a tripartite team of the lawyers, the economic experts, and the clients. And in that team, I think it's very important that it be considered an equal team with the three participants kind of contributing equally to the success. And the client side is often different to a normal kind of damages case or damages claim, because usually the clients are really subject matter experts in the oil and gas space. And I think you really need to bring the company's expertise to the price review. The second thing, which I think is key to kind of a successful price review team on the client side, is open and free and frequent communication. I think you can't afford to have silos where the lawyers work with the experts or the client works with the expert without the lawyer. You really need to bring everybody together, because I think you really need to see the price review as kind of holistic. It's a combination of the legal elements, the economic elements, data elements, industry elements. And you really need to bring everybody on the table communicating well to kind of get the best outcome of the price review.
Thank you, Matt. Before I ask you the couple more questions, Peter, would you like to comment briefly on either of those questions?
Yes, I certainly agree with Matt on what he said on the role of counsel. And of course, counsel is involved in legal interpretation, in advising on the law, but sometimes even interpretation, you look at the wordings of the clause in the context, the relevant factual matrix. What was the parties understanding the circumstances at the time of entering into the contract, for example. So it is very important for counsel to have a real grasp and understanding of the industry, both of the industry, the market at the time contract was entered into, and also at the time of the review period in question. So more so than in other types of disputes, the understanding of the industry is really key. And the other key point that Matt brought out is communication. That's absolutely very important. And frequently, I find myself attending many meetings with clients, lots of meetings, internal reports, and some clients are state-owned enterprises, for example. And so they would want many internal reports, sometimes at short notice. So keeping the communication channel open internally with client, with the counterparties, with the experts, and bringing the team together, that's key. A very important key role for lawyers in price review disputes.
Thank you, Peter. Matt, I understand that you have some experience regarding price review disputes with both European contracts and Asian LNG contracts. In your experience, what are the differences in how these contracts are drafted and in the parties' approaches? Also, under these contracts, the party seeking price review must establish that a trigger, i.e. entitling it, has been triggered. And what are some of the general and specific triggers that you have encountered?
Okay, thanks, John. I get asked this question often because I did work in my old home in Paris doing price reviews there, and then now I've been doing price reviews in Asia for 6 years or so. And I always give the same answer, which is, as the Thais say, it's same, but different. I mean, the price reviews are fundamentally the same in the sense that it's the same type of contract. It's a long-term contract that suits the parties for the long-term commitment that it provides, but typically that's based on a premise, which is proxy pricing, typically oil-based pricing, which is unstable, and therefore the parties acknowledge that it needs to be refreshed according to the market from time to time. So in that sense, they're the same, but if you want to get down to try to look at the differences, I think the difficulty is you need to look at two different things. You need to look at the price review clause, and you need to look at the market, and they call into to issue different things. So when it comes to the clause, and obviously each price review clause is different, it's bespoke, and these contracts are by definition confidential. So therefore, it's very difficult to say that the price review clauses in Asia and Europe are different because nobody knows. What I can say is anecdotally, based upon my experience, they have the same goal, which is to reset the price to the market, but they do have different features on average. So for example, to answer your question about triggers, it's true that most European price review clauses that I've seen have a substantive criteria for triggering a price review, typically a substantial change in economic circumstances in the buyer's market. And if that is not satisfied, you can't even have a price review and the price remains the same. Whereas in Asia, the vast majority of price review clauses I've seen don't have that element at all. They're just a price reset clause, which assumes that in the price review, the price will change. Now, the other element I'd say that's a bit different in price review clauses here is, as Wolfgang mentioned, the existence of in any case clauses. Those are a typical feature of European price review clauses that I've seen, which, as Wolfgang described, typically say that in any case, the buyer will have a price that will allow them to market the gas economically. Again, I've never seen one in an Asian price review clause. So that is my anecdotal comments, but with that, I bring a warning, which is the warning of stereotyping. And I use that word deliberately because of its negative connotation. That being, you can't assume that because a clause provides for delivery in Europe or delivery in Asia, that the price review clause will have certain qualities. To the contrary, these clauses are genuinely bespoke, and I think you have to look at each one based upon its real qualities. Now, the second thing that's different, obviously, between Europe and Asia is obviously the market. Now, here it's very difficult to compare Two, because obviously the markets are different. In Europe, you have a kind of an integrated market because of the European Union that's gone through waves of liberalization and is a very liberalized free market. In Asia, it's not the same. You have geographical constraints between the major purchasing countries, between Japan, Korea, Taiwan, China, India, for example. And also you have countries at a very different stage of liberalization. So therefore, I mean, if you compare Japan today to Europe today, obviously you see very different market criteria. But for example, if you compare Germany of 2003 with Japan today, you could see significant parallels. So I would say that, as I say, it is difficult to compare on a like-for-like basis between European price reviews and Asian price reviews. So I'm sorry, John, if that's not very satisfactory as an answer, but that's the way that I see it.
Thank you very much, Matt. Thanks for sharing your experience and insight with us. I will now turn my questions to Peter. Peter, you have navigated clients through both the negotiation and arbitration stages of these disputes. Are there stark differences in the approach in the negotiation and arbitration stages? And second, what is your position on how advocacy should be conducted in these highly technical disputes? Peter?
Well, thank you, John, for that question. Obviously, negotiation and arbitration are different stages in the process, and they serve different purposes, different end games. So there are differences. Regarding negotiation, well, in many common commercial contracts, for example, there may be a provision for negotiations before commencing formal arbitration. And often parties may go through the motion simply as a formality to satisfy the conditions. But one feature of a gas price review dispute is that the negotiation stage is actually a very important process. So not many price review disputes actually go through the whole arbitration process right to an award, at least not in Asia. So I believe it is useful to have external counsel brought in early at the negotiation stage, not just to provide advice on the interpretation of the clause, for example. The early involvement of external counsel is helpful in the sense that we can put in place a protocol to protect internal documents, sensitive memorandum with a professional privilege. And these documents might otherwise be subject to disclosure later on in a formal arbitration process. So that's one function of a counsel at this negotiation stage. And during the negotiations itself, counsel can perform a useful role to help formulate a negotiation strategy, prepare the client for the negotiation meetings, and be present to guide the negotiation process. And of course, it is important, very important, to involve the economic or the industry expert early at the negotiation stage, because they can provide valuable advice, guidance to the client on the possible reasonable position to take. Now, in some cases, there is a dispute as to whether there's, in fact, a price review process in the contract at all, or if the contract is vague. And in those cases, I've been involved in situations where counsel, we help to draft a discussion protocol so that we make clear the purposes of the discussions, that these discussions are not to be construed as negotiations or price review process, so as not to prejudice a party's rights. An issue to consider at the negotiation stage is whether it should be held on a without prejudice basis. Because the initial reaction for many people is that, well, in a dispute, we should be on a without prejudice basis. But for price review negotiations, there's something to be said about to consider whether there might be some advantages for the negotiations to be an open basis instead of a without prejudice basis. That's because in an open basis, I believe that experts from both parties may take perhaps a more balanced view, knowing what they say and the PowerPoint presentations, for example, may be used in evidence later. So a balanced view can help parties to narrow the gap and not take wildly differing views. And I've been involved in discussions where negotiations are partly on a without prejudice basis and partly on an open basis. So when it's a turn of experts to present, the discussions are open, And during the discussions on the law, for example, they were on a without prejudice basis. And I've also been in situations where there's a formal meeting where a large group is present with experts, lawyers, executives, and then there are side meetings at the appropriate time where the senior executives can discuss freely on a without prejudice basis. Now, another thing to bear in mind is that price reviews can occur periodically. In the case of Asia, perhaps every 4 or 5 years. So if the party takes a certain position in one review cycle, then take a different position in another review cycle. So what is said in a negotiation can be used against them in the next cycle, particularly if it's not on the without prejudice basis. Then when we come to the arbitration stage, of course, it's a different process. It's a formal process. There are procedures to follow, deadlines, timetables to adhere to. Experts will be more detailed in the report. But it should be borne in mind, as Angela said just now, that parties are in a long-term relationship. So in a long-term relationship, it is not just a matter of delivering and paying for LNG shipments. A certain level of cooperation between the seller and the buyer is required. There'll be frequent communications, periodic meetings to inspect facilities, discuss shipping schedules, delivery issues, and possibly even other additional purchases. So even if parties are not involved in a long-term contract, the number of players in the market is small and parties are likely to do business again. So in light of this background, it's important not to approach the arbitration in a manner that might harm this relationship. Over-aggressive stance or adopting certain language in correspondence, or memorials, or one-upmanship, I think is not necessary. It does not necessarily serve the parties well. One can be assertive, play fair, play well, seek an efficient resolution and be civil about it. Bearing in mind that this is not a claim for breach of contract, as Dr. Wolfgang mentioned just now. In the price review, essentially, parties are asking the arbitrator to find a commercial solution to the prices that they cannot agree. It's not a question of saying one person is default or one person is not. And of course, during the arbitration process itself, in parallel, parties can still continue to negotiate to find a solution.
Thank you, Peter. Matt, would you like to comment on either of those questions?
Yeah, thanks, John. Just two very quick comments to echo what Peter said. I think what you're seeing now in Asia is what I would call a kind of an increased professionalism when it comes to price review negotiations, because I think that 15 years ago when price review negotiations started, they just kind of assumed that because of the good relationship, they'd come to a pretty good commercial solution. So therefore, they didn't kind of lawyer up. They didn't get, kind of Boaz Moselle type experts in early. Whereas I think that now, and certainly more so in the future, you're getting this kind of people really kind of, as they say, committing a lot of resources so that by the time the negotiations start, they really have sophisticated positions with, with data and all kinds of things. The second thing I would say, just by way of an anecdote, is to echo what Peter said, that what's quite amusing about these price reviews is that if these contracts are very long term, so you often have multiple price reviews. And in Europe, what you see is, a position might help a client in one price review, and then 3 years later in the next price review, it may have the opposite effect on the price. So often parties do flip 180 degrees their position between price reviews because it serves them better in the next price review. And they say, well, listen, last time I was wrong. And in fact, now I realize the wisdom of your position in the last price review, which can be, let's say, quite amusing.
Thank you, Matt. So Peter, let me ask you a couple more questions. This is an issue that Wolfgang addressed earlier, but I'd like to get your perspective. In the absence of a price review clause, or when the clause does not provide for a clear right to arbitration to adjust the price, what scope do the parties have to review the price? And the last question for you is, what are the considerations parties should weigh before initiating arbitration? Is the risk of disputes on jurisdiction going to courts or associated costs too high in certain cases? Peter?
Well, I come across older long-term contracts that do not contain any price review clause at all. And even today, many long-term contracts contain some form of price review clauses, such as to meet and discuss, but they're silent on what happens if the parties cannot agree. So there's some ambiguity on whether parties can submit the pricing dispute to arbitration. And can parties rely on a general arbitration clause for this? It remains to be seen. It depends on the interpretation of the arbitration clause itself. Now, when there's no formal price review provisions, then this can give rise to a different type of a dispute. Sometimes parties, whether buyer or seller, may try to invoke the force majeure as a ground to excuse performance. This happened at the beginning of the COVID-19 pandemic. With the anticipated reduction of energy needs, some buyers have sought to avoid taking deliveries of gas by invoking force majeure. Now, the thing is that many of the international sale and purchase contracts I've come across in Asia are governed by English law. And so English law does not generally recognize force majeure as a legal concept. So you need to look at the language of the contract. And usually it means that it must be something beyond the parties' control that hinders or prevents the performance of the contract. But there must be some form of a physical obstruction, like a port congestions, quarantine, restrictions. And economic hardships alone are unlikely to fall within the scope of force majeure clauses. Now, you may recall that in the early part of 2020, Chinese authorities issued certificates declaring the COVID-19 pandemic as a force majeure event. Now, this may apply in the context of a domestic sale and purchase contracts governed by Chinese law, but in the international contracts governed by English law, for example, then the position could be different. In some cases, parties try to look at other provisions of the contract, for example, whether there are provisions, the take-and-pay clauses, how much downward adjustments they can make, or whether the deliveries can simply be pushed forward to the next year's annual adjusted contractual quantity. And in appropriate cases, I've seen cases where parties use political means to apply pressure, government-to-government negotiations. I've seen that resulting in price adjustments in some contracts, even in the absence of arbitration clause. Now, the second question relates to what are the considerations parties should weigh before initiating arbitration? Merits of the case is, of course, a key consideration, whether there's a price review clause, whether the conditions of price review are satisfied, whether there's an arbitration clause for price review. Now, the impact of an arbitration proceeding on the long-term relationship between the buyer and seller is, of course, an important factor. And whether this can be effectively managed during the arbitration process must be considered. Now, one thing to bear in mind is that if the contract provides for, say, a price review every 4 or 5 years, then depending on the movement of the price, a party may well take a different approach to the next round of price review. So if you have an arbitration award on legal issue, for example, then this may create a stopper situation. So a party may want to keep their powder dry in the meantime. And that's a consideration. And mention also whether the risk of jurisdictional dispute going to court too high. Now, I'm not sure whether that is a real risk or a real issue, because if the arbitration is seated in Singapore, for example, and then any application is set aside, the award will go before the Singapore courts, and the parties and details are anonymized in the law reports. But of course, in many cases, it's not too difficult to deduce who the parties are. And the fact that parties are in price review negotiations or even arbitrations have been reported by the industry media. So publicity may not be a factor, but I think a more important factor, the greatest sensitivity is information such as prices. Again, the risk of sensitive information such as prices and and things of such nature being made public is actually very low, certainly not in an SIAC arbitration in Singapore, and a very low risk in the Singapore courts itself. And the fact is that gas price reviews are high stakes arbitration. They are among the highest value commercial disputes. So for whatever reasons, this could be the overriding consideration before a party actually launches itself into arbitration proceedings.
Thank you, Peter, and thank you, Matt, both of you, for sharing your experiences and insights with us. Now, I will turn to Dr. Boaz Moselle, one of the leading experts in the field of price review disputes. Boaz, my first two questions for you, if I may. How does the role of a party-appointed expert in price review arbitrations differ from the role of a quantum expert in other types of disputes? Second, to what extent do tribunals look to experts for insights that might help them in interpreting the relevant provisions, as opposed to playing a pure quantum role? Wes?
Thank you, John, and good morning, good afternoon, good evening, everyone. Thanks for those questions. So first of all, the difference or similarity between the roles of a party-appointed expert in a price review as opposed to a typical quantum dispute, I mean, they are very different. So formally, obviously, it's the same. You're a party-appointed expert. You write reports. You're cross-examined, and so on. But in other, and you have the same level of seriousness, obviously, with which you need to approach it. But in other respects, they're very different. So first of all, as Matt and others have referred to, typically, as a party-appointed expert, you've been involved from before the dispute began. So you're typically engaged and involved as part of the team during the negotiations which precede any arbitration. And then and that is an indication already, I think, of that you have a kind of central role in the process which you don't have as a quantum expert. Then secondly, turning to the arbitration itself, I mean, it's hard to stress how different price review arbitrations are, at least in my experience, from a typical commercial dispute, a breach of contract or investor-state dispute. So in a typical commercial dispute, let's say, there are lots of purely legal issues at stake. There are lots of factual issues. There are fact witnesses. There are disputes about what happened and so on. And once all those things are resolved, if there's a finding on the merits that compensation is required, then you kind of turn to a new chapter in the book and you begin the quantum exercise. So it's generally very separate from the rest of the proceeding. Whereas in a typical price review arbitration, there are very few legal issues. There may be a dispute about jurisdiction. That's more common in Asia, I think, than in Europe. But apart from that, there are generally very few issues that are purely legal. There are really no factual issues that are in dispute other than the kind of facts that fall under the scope of expert testimony. In other words, facts about the markets. Typically, there are very few fact witnesses, 0 or 1. So really, the whole arbitration is about the expert evidence, and especially if the contract is under common law rather than civil law, which is typically the case for, at least for LNG contracts. So the quantum expert in a typical proceeding is really kind of the tail of a very big dog, whereas in a price review arbitration, the price review expert, the party appointed expert, is really quite central to it. A third point, and this relates also to your second question, the expert evidence is often key to issues of contractual interpretation. It's not just numbers and understanding the markets, although those things are very important. And the reason why is that price reviews, although they're very technical, they aren't just technical exercises. So there are typically issues of contractual interpretation, and those can be very material. So to give you an example, and it's a fairly archetypal example for certainly for Asian price reviews. If you have a price review clause and the price review clause says in one way or another that we need to reset the price in our contract by comparison with other comparable LNG contracts, then obviously that raises the question, what do you mean by comparable contracts? What are the criteria to apply? Often that will depend on what you think is the purpose of the price review clause. What was the intention? What is the intention behind the contractual language? So, for example, in this case, you might find that the buyer will say, look, the purpose of this clause is to ensure that I'm able to carry on, to make me competitive in the downstream market, that I can continue to sell the LNG or that I buy under this contract in competition with other buyers or in competition with other contracts that I have. So you need to compare this LNG with contracts that I have to compete with, and that would be a relatively small set. Maybe the buyer might argue it's quite a small set. You need to look at some new contracts that are coming into the market that I need to compete with. And then the seller might say, no, that's not what the intention is at all. The intention was simply that this price is a fair price by comparison with prices for LNG in the Asia Pacific region. And therefore, we need to look at a much broader range of contracts. So those two different interpretations, they're not about numbers, they're about intention, but they have potentially very, very big implications for how you perform the exercise, and they have very material financial implications. So for that reason, the questions of interpretation are tied in with expert evidence, and that brings me to your second question. Tribunals often and typically do look to the experts to help to make decisions on those kind of questions of interpretation. Now, obviously, they don't expect the expert to do the kind of interpretation exercise that lawyers do, but they expect them to explain their commercial understanding based on experience and economics. So yeah, in summary, they're very different experiences. The price review expert is much more central and is involved in a more holistic way, I would say.
Very, very interesting. So two more questions, Boaz, regarding experts. Are there differences in how an expert approaches a case when you're acting as an adjudicator in an expert determination proceeding versus a party-appointed expert in an arbitration? And are there some common economic themes that tend to arise repeatedly in price reviews?
Thank you. So on the first of those, I have to say that the use of expert determinations for price review is something that I've only come across in the last few years, because it's not something that's done in Europe, but it is done sometimes in Asia, and I've been involved in an expert determination. So it is it's an interesting and somewhat different way of approaching things. But as I'm going to explain, it's less different than you might think. But let's say my first point is it's likely that one reason why what you do as an adjudicator, as an expert adjudicator, is different from what you do as a party appointed expert is that you're probably a very different person. So the kinds of people who get appointed as experts by parties in price reviews, they come from a very small pool. There are maybe half a dozen gas price review experts who have been involved in, I'm guessing somewhat, but probably more than half of all price review arbitrations in the last 10 years. It's for better or for worse, it's a small number of familiar faces, and therefore those people like me essentially, are unlikely to be chosen as adjudicators in price review expert determinations, apart from anything else, because there would be the very high potential for conflicts, actual conflicts or perceived conflicts. The kind of process that leads to expert determination typically you end up with someone who's more of a general industry expert, but doesn't have a lot of experience in price review arbitration. So that's the first point, is you're a different person. And secondly, in other kinds of expert determinations, you might think, well, it's a technical question, you give it to the expert adjudicator, they go away and they come back with an answer. Price review determinations, because as Angela said, there's so much at stake, there's a lot of money at stake, they actually end up being much more like arbitrations. So the one that I've been involved in as a party appointed expert, it looked a lot like an arbitration. Both sides had very distinguished counsel, both sides made legal submissions, both sides appointed party appointed experts to make submissions to the adjudicator. There was a hearing, there was cross-examination, the whole caboodle. So it wasn't the case that the expert adjudicator just got to go off and make their own decision. They were more like an arbitrator without legal training. They had their own legal advisor, but with, I suppose, more technical knowledge. So they are very different. They're very different roles, but the actual proceeding is less different than you might think. And lastly and quickly, you asked about economic themes. Yes, there are some economic themes that come up again and again. That was the case in Europe, and I think it is and will be the case in Asia. So this isn't an exhaustive list, but to give some examples, often, as I've said, there's a question of interpretation. And for economists, we tend to think that a lot of what contracts do is allocate risks. So often one theme is trying to understand how, when the parties wrote down this language, which, as Matt said, can be quite vague, how are they intending to allocate risks between the parties? Because price review clauses are intended to deal with an uncertain future. So they are about sharing of risk and pooling of risk, or allocation of risk. A second point is more of a statistical issue, if you like. It's sort of data quantity versus data quality. So in my experience, Asian price reviews are very focused on price benchmarking against comparable contracts, as I've said. And you might choose a small number of contracts that look very much like yours, and that has the advantage that it's high quality because they look like your contract, but it's low quantity and therefore maybe statistically less reliable. Or you could choose a bigger basket of contracts to benchmark against, higher quantity, lower quality, and that's a trade-off, and making that trade-off is a common theme. And thirdly, and again, I think Wolfgang made reference to this, a very common issue in European price reviews, and I expect this will be the case in Asian as well, is the value of the flexibility that's built into the contract, which is interesting, is technically complex, and varies a lot from situation to situation. And that's it.
Well, thank you very much, Boaz, for your valuable insights on the role of experts, which clearly is very, very vital in these type of disputes. Now we return to Angela to ask some questions to our panelists, and I think you have a question for Wolfgang, Angela?
I do, thank you, John. Wolfgang, I am interested in your comment about price reviews being different to price review arbitrations being different to other arbitrations, and the arbitrator's role. So can I ask, what are there specific qualities that you would look for in an arbitrator for price review arbitration? And is it different to other arbitrations?
Wolfgang, you have to, Wolfgang, you're on mute if you can.
Apologize. Yes, these arbitrations, I think it came out from all of the participants that these arbitrations work in very different ways from the usual commercial arbitrations, where you have the issue of a breach of contract and then you go and pursue matters. So the arbitrators in the gas price review arbitrations, first of all, must be able to work with experts who are in fact economists and not forensic accountants. Yeah, I'm saying this in the direction of Boas. They must understand where economically the parties come from. They must have a certain feeling for these issues. It's not the usual lively pleadings that we do, but we have to deal with numbers. We have to be able to understand this. I said before, the arbitrators must accept to work really hard, and not just in terms of hours, but willing to open their mind and enter into a field which, as a normal lawyer, you're not necessarily trained to. And you have to build up experience, and you have to be working, as it was said before, as a team, because you associate the experts at a very early stage, and you have to be very close with your counsel, and you have to convince everybody you are the coordinating element. And therefore, an arbitration is not always obvious. I mean, what I would like to make as a side remark, because it hasn't been said before, arbitration in gas price issues have high economic stakes. Now, a lot of clients say, this is expensive. I think Peter said these arbitrations are expensive, but then I shoot the questions back to you, Peter. Where do you find investments where you get a return or can get a return of 40, 50, 60 times your investment? Because when you win a $200 million arbitration in gas price and you have to invest 3 or 4 millions, where do you get that return? So, but also you have to be able to convince the arbitrator as counsel that you're not abusing the system, that it's something which you can only build up with experience. And I think that there are a number of arbitrators, far more than there are experts, because Boaz said there are maybe 5 or 6 experts, and I agree with him, that's true. They are the ones which are most frequently named. So there are many more arbitrators, obviously, who are having experience in that field, but there are not that many after all. Unless you consider that some people do, once you have done one arbitration, you can tick off a box of being an expert in the field.
Thank you, Wolfgang. Angela, I think you have a question for Matt, right?
I do. Matt, thank you for your reflections on price reviews in different markets. And I think my takeaway is that they're same, but different. So that's very easy to remember. But because you've had experience with price reviews in both Asia and Europe, can I ask the question of how important is the governing law when it comes to prospects for a favorable arbitral award?
Thanks, Angela. I mean, I would say that the answer is on the core price review. If it's not 0, it's close to it. It approaches it, in the sense that, to my mind, in the core part of the price review, the only place the applicable law comes is interpreting the contract. But I've done price reviews under Swiss law, Swedish law, Dutch law, English law, New York law, and all of those laws have their own expression of how you interpret a contract, but they don't differ wildly. They all go to the fundamental tenet of looking to the party's intention, and in suitable circumstances, taking into account things such as the commercial background, the trade, the industry, etc. So I think that once you take that very minimal part out, there's little space to apply the law. Now, the one thing I would say is I'm only talking about the core of the price review, because price reviews do tend to throw up other issues. So, for example, in European price reviews, it became very fashionable, kind of à la mode, to raise competition law issues and argue that whatever the other side was doing was anti-competitive. Now, if that happens on ancillary issues, there, of course, it's usually a question of just pure applicable law, in that case, EU competition law. But as a general matter, they're not very legal disputes.
That's very helpful, Matt. Angela, I think you have another question for Peter.
Yes, if I may, thank you. Peter, you gave some insightful advice on for the parties on how to approach price reviews. Do you have any practical advice for in-house legal teams on how to, maximize chances of success in any potential future LNG price reviews?
Thank you for the question, Angela. How do you measure success? I've come across situations where both parties claim that the award is favorable to them. The buyer may say, well, it's a good award for them, and the seller says it's good for them. Both claim to be successful. I would say that success is not necessarily measured in winning an arbitration. I tend to think that success is being able to place yourself in a good negotiating position, to be able to negotiate effectively and able to reach agreement on the price adjustment, if at all, so that both parties find that as an acceptable commercial solution. And I think that is a success. And of course, if the matter goes down the arbitration path, then success could be measured by both parties obtaining a desirable outcome in terms of the pricing. So the starting point, I think, is even at the stage of entering into the contract in the first place. So what is stated in the contract is very much influenced the ability to review the price. And an important consideration is whether or not you want to include a more comprehensive price review clause that you see in Europe. That may not necessarily work in the situation, a particular situation you're in, bearing in mind that parties may want to have a certain level of ambiguity over here to leave room for maneuver later on. And again, Matt has mentioned about early involvement of experts, external counsel at the negotiation process. I think that's also a key level of success. I think that, to me, an important key area is communication. Communication between lawyers, communication with the in-house counsels, with the management team, with the operational team, with the experts, and making sure that the management have a good idea of, they have the right information to make informed decisions. And in some cases, the company has many shareholders, consortiums, so interests are not exactly aligned. So it's important to be able to navigate through all these differences so that the parties, the company, the clients can speak with one mind.
Thank you, Peter. And we have, I think, less than 3 minutes left. And I want to thank the audience first for their interest in this topic, because we have a lot of questions. Unfortunately, we can't get to many of them. And I'll just ask one, but we have time for one question because I think the answer is very quick. And I'll go to the first question that was sent to us. It says, why don't the contracts call for mediation if the parties are unable to resolve the issue through the mechanism itself, or at least before resorting to arbitration, or do they normally do? If anybody wants to take that very quickly.
I can take that, John. Oh, Wolfgang, go ahead.
No, go ahead, Matthew.
Oh, I would just say quickly that I've rarely seen a specific mediation mechanism. I think there's a question mark about whether it would be that useful, simply because the fact is that normally you've had extensive negotiations, sophisticated negotiations, and the parties normally, really thrashed out thoroughly their positions. But that said, I think it could work, but you'd need a very sophisticated mediator who really knows oil and gas, in particular LNG, very well. And I think if you had that person, it might help.
Wolfgang, would you like to say something or add something?
Yeah, I fully agree. These negotiations, which are sometimes official and unofficial in two different strings, which I've accompanied from time to time, they are very extensive and they take time. And then you have a mediation, which would again take time. And then the result of the mediation is, of course, non-binding. And once you have had lengthy negotiations, mediation has a very low chance of success, and then you lose even more time, and you feel you ultimately nevertheless will go to arbitration. That's the reason why.
Thank you. I want to extend my thanks to the SIC for helping us put this together, and more generally for their excellent work and thought leadership in international arbitration. I also want to again thank each of the panelists for taking the time to prepare and for speaking to us at length. I had promised in the beginning that at the end of this webinar, each of the audience members would find themselves enriched with some knowledge about LNG price review disputes. And I think we have more than lived up to that promise. So thank you very much. Michelle, floor is yours.
All right. Thanks so much, John. And thank you to all of our speakers for that really informative and interesting session. Thank you very much to our participants for joining us today. This brings our webinar to a close. We do hope you can join us for future SIAC webinars and courses. More available is on the SIAC website. So please do feel free to peruse our events calendar there. Take care and have a great rest of your day. Thanks, everyone.
Thank you.
Thank you.
Thank you.
Thank you.